Some of you have probably seen the main source of what I'm going to talk about, which is April Imholte's first appearance, which had a little bit of a doozy attached to it. It had a motion to dismiss. We don't normally have those on first appearances. They sometimes have a place. They don't always have a place. And you've probably seen people like analyze the motion, or you've seen people watch the hearing. We're going to do maybe both of those, even though we know the outcome of the motion hearing. Let me just say from the get-go, the case was not dismissed at the first appearance. I don't know if this is one of those things where you don't plan to have that happen because you're probably not going to win, but you can hope. Also, some things can come out of it that are semi-useful, and I want to talk about those things today. I don't know what anybody else has said about this thing, other than there's a lot of chatter about where April seemed to be when she was on her Zoom call. The background was really blurry, so I don't know where that was, obviously. I hope the court doesn't find out. That would be so bad. It'd just be terrible. Oh my God. Hopefully they never find out where that was, because that would somehow affect something somewhere. But yeah, so here's what I figure. I figure, hey, I can watch this thing. We can read this paper. We can talk about what happened, and I can give you guys maybe some insight that no one else can. I'm not sure if you want that or not, but that's what you're going to get. There were some interesting bits that happened on that hearing. I was kind of surprised because it's like 10 minutes. It's not a lot to do, not a lot of time. And it's amazing that the state can be the state in such a short fucking time. But hey, that's what they do. Shut up about court cases, Nick. Well, no, I don't want to. Ricardo Law has no idea where April was zooming from, and no respect for his audience. She was right here in my office, you weirdo. What do people think it's like a mystery or like a secret? What kind of, I honestly, I don't even understand the internet. I think you guys can find it if you look. People have gone so autistic that they don't even remember that, like, I don't think they even remember what they're, I don't even know how to describe this. It's not mad at, it's not marveling over, it's not watching. They just forget what they're even in, so that everything becomes interesting even when stuff isn't. It's so weird. It's marvelous to watch. But guys, don't tell the government she was in my house. They'll go back in time and arrest her. That's been one of the funniest things to watch today. Is everybody's like, "Whoa, Nick's busted now." It's like, God. Busted with what? Oh my God. It's very funny. I don't know. Maybe it's not funny. What was it like being the corner demon for April? It was good. It was good. I had I had one of those towels and like a bucket, kind of like doing that thing in case it got too warm. Okay, here we go. Count one. So here's the complaint against April Imholte. Yes, it is April Imholte. No, this is not the correct address, actually. This is weird. I'm not sure why this address is here, but April has a different P.O. box. I think there was someone out there who maybe lied and said that something was sent to a P.O. box that belonged to me when it actually wasn't. It was sent to a P.O. box that belonged to April. But someone out there suggested that it was mine, and then that lie permeated into some fact, I guess. But that was never true. The person who said it knew they were lying too. which is interesting. But that's the way these things go. So this one, though, this is my P.O. box. I'm not sure why it's on here. So just as a hypothetical, there's a couple of things about this complaint that should stand out right on their face, right? April is not April Imholte anymore, and the address is wrong. So there's a question about if she's properly served in this case. And before you jump down my throat, okay, which sounds like a fun time, before you jump down my throat, hold up. If she was improperly served, or if she wanted to quibble and bicker about the name, the ultimate outcome is going to be nothing. Like, it's not going to be profitable. Like, if you get the summons and they sent it to the wrong address, well, you could argue that you were improperly served, but what they do is they just issue a bench warrant and arrest you, drag your ass in. And then you go in and your defense is that you were improperly served. So, like, some of these things, if you get notice of it, you can be a pain in the ass and try and fight it. Like, she could probably be a pain in the ass and try and fight about her name, but like, what good is it going to do? It's not going to, they're not going to be like, oh, you know what? You're right. That's the wrong name. Here you go. You win forever. That's not how it works. The law has, people talk about technicalities, getting off on technicalities. You're never getting off on a technicality. You're getting off on a rule. There's a difference. Getting off on a technicality would be they sent it to the wrong P.O. box. You're no longer, like, you're not going to go through the process of being charged because of that minor mix up. It's like, well, no, they just send a new one to the right P.O. box. So the court is very correcting of technicalities. It's one of the reasons I hate that expression. I think a lot of defense lawyers do, because it trivializes what's happening. If someone's winning on a technicality, they're winning because the government broke the rules that the government has to keep you safe from the government. Those rules are often called rights or liberties, but sometimes they're just regulatory rules that the government must follow as well. They're not always boiling down to a right, but it's not a technicality. It's a really fucking important thing that exists. And if you minimize it to a technicality, then you're a bootlicking statist pile of trash, and you should be thrown into a furnace or something. I think they tried that in a different country, but you don't, please just start reframing your mind on the technicality thing for all of our sakes, because the amount of Karening that's going on in the world right now is trying to eliminate technicalities, and those technicalities are your rights. That's the thing that is supposed to prevent crazy shit from happening to you. But here we go. Charged with 5th degree possession, schedule 1, 2, 3, 4, not a small amount of marijuana, felony amount. Not a small amount of marijuana is this is kind of a holdover of how the law was written, because Minnesota had decriminalized marijuana. So if you had a small amount for personal use prior to last year, I think it was, then it was a small amount was a non-criminal act. It was still a crime, but we don't have to get into it. But if you've got more than a small amount of marijuana, you had a felony. Now that part is really like, it's really not a small amount. They upped the amounts quite a bit, but we don't need to get into that because she is accused of possessing more than 0.25 grams of cocaine, which is what brings us into the felony level. If it's less than 0.25 grams of cocaine, it would be a misdemeanor or gross misdemeanor, I think. Who cares? So here's the probable cause statement. And I'm reading the probable cause statement. I was going to go through the fucking motion. Let's do them both. What else are we doing? We'll go through both the statement of probable cause and the motion, because I think it'll be helpful to have them both. Those Almond says, does April being charged lessen the burden of some quantity in yours and Kayla's cases below felony threshold, perhaps? Well, see, this is where it gets kind of tough to talk about things. We'll have to see. Minnesota has a couple different theories of possession, and one of those theories is joint possession. It's where multiple people can own all of something at the same time. And all of those people can be individually guilty or not guilty of owning a thing, any portion or all of it. And one person can be guilty of owning 100% of it, and so can another. That's how joint ownership ends up working. It's kind of weird in concept, but part of the problem here is, and this is what's brought up in the motion, is there's no particularity to the actual probable cause statement. So from this probable cause statement, we have to try and figure out what actually April is accused of possessing. So let's see if we can do it. The complainant states that the following facts establish probable cause. Your complainant is a licensed peace officer, is employed by the Kandiyohi County Sheriff's Office. In this capacity, your complainant believes the following is true and correct. Who wrote this? Is this Brannis? Who wrote this one? Oh, no, it's Kent Bauman. This is the chief deputy. This guy was at my house. He was walking around being chunky. Like, when you're the chief deputy, you don't have to be as in good a shape as the other ones. Oh, that shape is almost universally round, to be clear. Did you guys ever see SWAT? Remember how LL Cool J looked when he was all jacked out of his mind? He's got like a 9-pack of abs. None of these guys look like this. All of these guys look like day old jelly donuts. Okay, so on May 23rd, 2024, at approximately 9:13 a.m., a search warrant was executed at. Oh no, there's my house. Me and Kayla reside at the residence. As law enforcement approached the residence, Nicholas was traveling southbound on 51st in a vehicle. I was traveling southbound on 51st in a vehicle. Interestingly, I was not home. Nicholas Rekieta was stopped by law enforcement. That is not quite true, actually. I'll tell you the real story, guys. I saw a fuckload of cars going by that all said sheriff on them, and I thought my house was being swatted. So I pulled over and stopped on my own. I was not stopped by law enforcement. When I stopped, I saw a law enforcement car turn around and come back to me. So I waited for them there. They act like they stopped me. These lazy asses didn't do shit. Upon knocking on the door, a juvenile female opened the door and wouldn't let me in. This is false. Straight out false. A juvenile female did not open the door at all. I don't know why they wrote that down, but okay. Nicholas Rekieta would not provide the door code to enter the residence. That's true. I just said, show me the warrant and I'll give you the code. I'll walk you in myself. But they didn't want to do that. I wasn't there, to be clear. Again, they kind of are. These complaints are written in this real muddy sort of way, and I'm not sure why. Like, they can't just write clearly about what happened, but law enforcement entered the home utilizing a door ram and a big boy wielding it. Upon entry, law enforcement located Kayla Rekieta and April Imholte, and 4 juveniles were also in the home. That's not true either. Good job, guys. Got that one wrong as well. There were only 3 juveniles in the home. Kayla Rekieta and Imholte were located in the master bedroom. Officers noted the home was extremely cluttered. There were clothes everywhere, dirty dishes, dust, and an overall dirty home. It's almost like people lived there. Nicholas Rekieta returned to the home with law enforcement. I returned to the home? I went to the home with law enforcement. He demanded a copy of search warrant. I forgot the article. When given a copy, he looked at it and threw it on the ground. That's true. During the search, law enforcement located the following in the master bedroom. Following items are located in the master bedroom near the nightstand. This is interesting because this is a lot about me. April is not the star of this show. Yellow snort tube positive for cocaine. Black vial with white substance inside that field tested positive for cocaine and weighed 2.2 grams. That's a run-on sentence. 2 credit cards listed to Imholte. The yellow snort tube and the black vial containing cocaine were found directly on top of the credit cards. 2 .22 caliber spent shell casings on the floor of the nightstand in the master bedroom. Guys, one day I'm going to show you all about those shell casings. It's kind of funny. It's funny because they're like, we going to take your kids. And I'm like, I don't even have a 22, you dumb fuckers. It's just from art. The following item was located underneath the bed in the master bedroom. 6-hour AR with several magazines and loose ammunition. Serial number, whatever. Following item was located in the master bedroom dresser. Glass container with metal filter and grinder and glass container that field tested positive for cocaine. The following items were located in a safe in the master bathroom. Bag with cards and dollar bill that field tested positive for cocaine. Large corner cut baggie with white powder that field tested positive for cocaine and weighed 18.96 grams of packaging. 3 small baggies that field tested positive for cocaine and weighed 5.49 grams of packaging. 8 green colored tablets that field tested positive for ketamine. Digital scale that field tested positive for cocaine. Metal pan with white powder on it that tested positive for cocaine. 2 snort tubes and 2 metal cutters. Snort tubes tested positive for cocaine. Following items located in a safe in the master bedroom closet. This is all alleged by the county, by the way. I'm not admitting to any of this shit. This is their list. $100 bill with white powder residue that field tested positive for cocaine. Bindle white bag. What's a bindle white bag? With white powder substance that field tested positive for cocaine. Cocaine scooper. So like a pooper scooper? Like, you know, the things that you pick up dog shit with, like little claw thing? What is that? 2 baggies with a baggie. 2 baggies within a baggie with a funnel. That's confusing. Unknown brown substance. Oh, I hope it's poop. Additional firearms and ammunition were located in the garage. Imholte's purse was located in the hallway inside the master bedroom, leading to the attached bathroom. The total amount of measurable cocaine in the master bedroom was 26.67 grams with packaging. It's a big package. Cocaine is a Schedule 2 controlled substance. Ketamine is a Schedule 1 controlled substance. That's not true. Ketamine is a Schedule 3 controlled substance. Good job, drug recognition experts and sheriff of the county that I'm in. Detective Pomplun, this guy's a winner, met with Nicholas Rekieta outside the residence. He was read his Miranda rights, and he agreed to speak to officers without counsel. Nicholas Rekieta indicated that he sleeps in the master bedroom with Kayla Rekieta. He indicated that Imholte was at the home visiting. Nicholas Rekieta and Kayla Rekieta were placed under arrest. While being placed under arrest, Detective Pomplun noted several injuries to the arms of Nicholas Rekieta that appeared consistent with sores that are common with controlled substance users. No, they did not. They were It's funny because one of the pictures that they have of my sores on my arms, the guy handcuffing me has a sore on his arm because some people get sores on their arms, but okay. They're transported to the Candy Ojai County Jail. Kayla did not speak with officers. At the Candy Ojai County Jail, Nicholas Rekieta was again read his Miranda rights. I got Miranda twice. And agreed to speak with officers without an attorney. Nicholas Rekieta refused to answer any questions regarding cocaine or other controlled substance use. Nicholas Rekieta indicates that he lives in the residence. He stays in the master bedroom with his wife, Kayla Rekieta. Imholte was a friend who was visiting and does not live at the residence. While being booked into the jail, Kayla Rekieta requested that her prescription medication be brought to her. Upon reviewing the prescription bottles for Kayla Rekieta that were brought to the jail staff found 2 unknown pills and gummies in one of the prescription bottles. 2 unknown pills and gummies. Okay, both of those are plural, but they're different things. But there's 2. That's confusing. These items did not match the prescription on the bottle. Kayla Rekieta informed child protection workers that Imholte is their live-in nanny. This is not a true statement by the drafting officer here. If you go back and read my complaint, this is a fun game of that insular telephone that we're talking about here. This is one of the instances where it happens. It happens in another place too, but Kayla did not inform a child protection worker that Imholte is a live-in nanny. A child protection worker asked Kayla, according to the other complaint, what the status of our live-in nanny, Cheney, actually, what the status of our nanny was, our former nanny, Cheney, who she described as basically a live-in nanny. The CPS worker did. Kayla indicated that April was our nanny. And the CPS worker took that and made that into April being a live-in nanny. She did not say she was the live-in nanny because we have never had a live-in nanny, ever. Our former nanny was not a live-in nanny. April is not a live-in nanny. We don't have a bedroom for a live-in nanny. All our bedrooms are full of kids. So, that being said, this is one of those things, though. It gets put in the complaint that this is what is said. That's not what was said. That is what the CPS worker decided to label our former nanny as, even though she never lived in our home at all. She says, technically or basically, I can't remember the exact wording, but it's either technically or basically a live-in nanny. And then that gets put onto Kayla as her making this claim, but that didn't happen. But of course, now what has happened? The officers have used that statement in part as a basis for bringing this charge. So here we have a government worker. And again, this isn't like this, some malicious lie, right? This is some statement. I mean, maybe it is. I don't know. I'm not going to accuse her of that at this point. She lies in other places plenty of times. But giving her the benefit of the doubt, this is a statement where she's like, well, you guys have like a nanny or whatever, right? Like a live-in or something. And then because that's not our nanny. Actually, April over there is our nanny. She replaced the former one. She goes, oh, so the CPS worker goes, that's the live-in nanny, and writes it down. That becomes now a fact. But it's not a real fact. It's great. So please take notice, pursuant to Minnesota Statute 609.49, intentional failure to appear for duly scheduled court appearances may result in additional criminal charges in addition to any arrest warrant that may otherwise be issued by the court. This is weird, because what do you guys see where the crime is? I know you can find, you can try and find a crime like in these facts. You can say, okay, well, here, this might be a crime. This might be a crime. This might be a crime. Where's the actual accusation in this statement of probable cause? Now, they say in the complaint that she's accused of owning more than 1/4 gram of cocaine. Well, they've got a couple different alleged sets of cocaine to choose from. Which one is it? And herein lies the problem. What is she accused of owning? So this is where you come into having the motion to dismiss, which I'll have to pull up because I didn't grab it just a second ago. See if I can get it now. But yeah, I wanted to get into that live-in nanny part because it's this interesting place where the county's created this. And again, it's not necessarily nefarious. It's not like they went in there like, we're going to plant a live-in nanny in their house. Like that's weird, right? Could be helpful for some people, but that's weird if the county were to do that. They didn't have to, right? They have just a little inaccuracy, this minor inaccuracy where someone uses, again, a common vernacular of a live-in. But if you don't have a live-in, someone says, oh, is that a live-in nanny? And you're like, well, kind of, or whatever. Like you might do that. And it doesn't matter normally, right? Because who cares if you label someone a live-in or not normally. Now, though, that label has partially resulted in these charges. So it's kind of fun. On occasion, an attorney may find it useful to file a motion to dismiss if they believe there's sufficient grounds to dismiss a complaint outright at the beginning. They'll file a motion to dismiss. Now, this usually does not actually resolve the case, even if you win. It does dismiss the complaint itself, and the government would have to then refile if they wanted to go after you. And it can be dismissed with prejudice, but oftentimes they'll just dismiss it without prejudice and allow the government the opportunity to amend the complaint, offer more clarity. Now, if it's clear that the government doesn't have access to the facts to actually support any kind of claim, a judge may dismiss it outright with prejudice and say, okay, yeah, you got nothing. But if they find that there are sufficient facts and maybe there just needs to be more particular wording, they can offer the state the opportunity to rectify the problem. But because you really aren't typically winning this motion and winning the case, it doesn't really hang around. It doesn't really come up as often because usually you're going to just wait until your Rule 11 Omnibus hearing in which you would make your pretrial challenges. That's what I'm in the process of right now. Is that you would go to your Rule 11 hearing, and that's when you challenge probable cause for the charges, probable cause for the warrant, et cetera, et cetera. Any of those dispositive motions are resolved there typically. You're also, at that point, you're going to have some discovery come through, and things are going to kind of be rolling. And that's why it's a little bit better position to go after this. And that's what ended up happening here. The judge basically said, probably want to refile this around the omnibus time thinks it's a little premature here. I actually disagree with the judge, but not in a harsh way. I mean, there's no practical impact to the decision going this way, so it's not that big of a deal. But I disagree. I think that this complaint is facially deficient, and I think the motion here is correctly argued. When we watched the video, there's some things that I thought maybe could have been brought up. Now, I'm not criticizing her lawyer at all. He seems like a cool dude, but it's there's some things that could maybe be brought up that I'll, if I remember them, I'll try and mention them as we go. But he really doesn't. There's not like a big fight that goes on, because you don't really need to have a huge fight here. What he gets out of this is immediately apparent, and we'll talk about it in a minute. Okay, so here we go. This is a motion to dismiss. The defendant, April, through her attorney, Thomas Gallagher, and pursuant to Minnesota Rules of Criminal Procedure 11.03, hereby moves to dismiss the complaint. This motion is based on the files, records, and proceedings herein, and on the following grounds. Complaint does not comply with Rules of Criminal Procedure 2.01. Complaint fails to allege facts amounting to probable cause to believe that an offense was committed. This actually, right here, is true. Because it just doesn't say which facts actually show any kind of possession. They leave a couple breadcrumbs, but the complaint fails to establish probable cause to believe the defendant committed an offense. There's another one, like, even if you can find an offense committed in the fact pattern, it doesn't say that April committed the offense. And then fourth, further moves the court pursuant to 5th and 6th Amendments to the U.S. Constitution for an order dismissing the complaint for lack of sufficiency, or in the alternative, requiring the government to furnish defendant with a bill of particulars. Now, none of this was granted by the judge, but it doesn't matter. Like, again, the judge didn't order a bill of particulars, but the government does, or the state does, clarify their position on what April is alleged to own in this case. So we actually do get some of that information out of this hearing. But here we go. So here's the rule. It sets forth the content requirements for complaints. Now, again, think back on the complaint we just read and see if it meets this in your opinion. Maybe it does. The complaint is a written signed statement of the facts establishing probable cause to believe that the charged offense has been committed and that the defendant committed it, except as modified by Rule 6.01, Subdivision 4. The probable cause statement can be supplemented by supporting affidavits, statements signed under penalty of perjury pursuant to Minnesota statutes, sections 358.116, or by sworn witness testimony taken by the issuing judge. The complaint must specify the offense charged, the statute allegedly violated, and the maximum penalty. The complaint must also conform to the requirements in Rule 17.02. And here's the comment to that rule. Because the complaint is accessible to the public and documents supporting the statement of probable cause can contain irrelevant material that is injurious to innocent third persons, as well as material prejudicial to the defendant's right to a fair trial, it is recommended that a statement be drafted containing the facts establishing probable cause in or with the complaint, and the irrelevant material be omitted. Now, interestingly, most of this complaint is actually irrelevant, right? April is charged, as we'll find out from the actual hearing, she's charged with owning this alleged 2.2 grams from a black vial located in the bedroom. The government did not allege that she was charged with ownership of anything that was allegedly pulled from the safe from the master bathroom. Okay. So in this now, we have a big question. Well, why the fuck do you talk about the safe and what's in it and all of the other stuff involving the house? Like, why is that relevant to April being charged with owning this one thing from one spot? In my opinion, this complaint does not conform to the rules. However, we get into the practicality part of it here, right? The practicality part is, are we achieving the goal? Now there's more particularity to the allegation. The specific alleged controlled substance has been identified, and now that information is available to the defendant. So we've achieved that goal through this hearing. even though the complaint, in my opinion, is facially deficient. The complaint alleges a criminal violation of felony possession of controlled substances, 5th degree, and contains 2.5-page statement of probable cause alleging various facts to be true. Defendant's name is mentioned only 5 times in the statement of probable cause. I think some people have quibbled on this and said it's 6. I didn't check. I don't care. If it's 5 or 6, it's still pretty. Wow, the 6th one, that makes it reasonable. The statute charged requires unlawful possession. Minnesota statute 152.025 subdivision 2 parenthetical 1, but the complaint does not allege facts to be true that defendant unlawfully or otherwise possessed illegal drugs. It only says that she was a guest in someone else's home when police executed a search warrant and found illegal drugs. Accordingly, since the complaint contains no factual substantiation or probable cause, it must be dismissed. It's important to note that the complaint doesn't say she is in possession of anything in there. They just don't say it, which is weird. I don't know why they didn't just write that down. Like, if you're going to allege that she's in possession of a thing, which is, you're charging her with the crime of it, I think it's safe to allege it. You don't have to be scared. Like, they should just write it, but it's just bad writing. Probable cause exists when a person of ordinary care and prudence, viewing the totality of circumstances objectively, would entertain an honest and strong suspicion that a specific individual has committed a crime. Again, it has to be a specific individual and a specific act. A person's mere proximity to criminal activity does not in and of itself establish probable cause to arrest. Since the complaint makes no allegation the defendant possessed any illegal drugs, but merely she was present in the same house, it should be dismissed for lack of probable cause. The 5th and 6th Amendments require that a complaint sufficiently apprise the defendant of what he must be prepared to meet. This is Russell v. U.S. This is well-established criminal procedure case law, is what he's going to go through with Russell and Hernandez, Wessel. These are all like landmark cases in this coming through. Well, some of these are coming through the appeals courts. Others, Russell here's Supreme Court. The complaint provides insufficient information to allow a defendant to form a defense and should be dismissed. At a minimum, she's entitled to a bill of particulars ordering the government to clarify the charges with details sufficient for her to understand and respond to them. A bill of particulars serves to inform the defendant of the nature of the charge against him with sufficient precision to enable him to prepare for trial, to avoid or minimize the danger of surprise, if you say surprise, at trial, and enable him to plead his acquittal or conviction in bar of another prosecution for the same offense when the complaint is too vague and indefinite. U.S. v. Hernandez, see also U.S. v. Wessel. The district court, in its discretion, may order the government to provide requested additional detail where the particulars set out in the complaint fail, sufficiently to apprise the defendant of the charges to enable him to prepare a full defense. That's U.S. v. Garrett. The complaint alone will be sufficient when the elements of the offense are delineated and the general statement is accompanied by specific facts constituting the offense. That's U.S. v. Helmel. It's axiomatic that a defendant is entitled to know what behavior is alleged to constitute the defense he is charged with. U.S. versus Idris. And then that's ordering a bill of particulars detailing the elements of the 3 counts of the specific facts establishing those offenses. The defendant, for the reasons respectfully requests the court grant her motion to dismiss the complaint for lack of probable cause. And that's signed by Thomas Gallagher. Okay. Sorry, we kind of burned through that. But this is just an outright shot across the bow, right? Like, you're not doing your job well. There's a whole lot of reasons that the DA may not be doing their job well. DA, I say DA, it's county attorney, assistant county attorney. But the assistant county attorney may not be doing their job well for a lot of things. Like, I won't get too deep into speculation. I know you guys are smart and will figure out some reasons why that might be, but I have reasons to not talk about it. Unfortunately, boring. But there are some reasons why this just might not be a well-drafted complaint. And frankly, this motion kind of sets the tone, right? Hey, let's get fucking gear here. Like, let's figure this out. You can't just generally allege some criminal activity has occurred without saying what it actually was. So it kind of gets all these things jumbled together, but we need them close in proximity so we can actually analyze what happens. Because I want to point out another subtle lie that happened. And again, it matters. This is an actual thing that ends up having an impact. And I want to show you guys how government just fucks you in little ways over and over again. Because, well, that's what they do. Nick Rye says, has it been established who April is in relation to you? Employee, friend, lover, wife's lover, something else? Ooh, has it been established? I don't think so. Has it been established? I don't know. What do you guys think? That's probably a mistake. You guys don't answer that. What do you think? I don't know, man. It depends on what your definition of established is. Like, and I don't mean that in a shitty Bill Clinton way. I mean that in a way of like, who do you need it to be established for? It depends on what you mean by like, is it established? Like, we're not at trial. So it doesn't have to be established in any way for the court at this point. Anything in regards to the court right now, all facts as they exist are alleged. There's no fact finder right now. We don't have a jury. Juries are fact finders, or judges in a bench trial are fact finders. Since we don't have an actual fact finder appointed in any of the cases yet, we don't have any way to establish facts for the purposes of court. So right now, anything and everything is simply alleged. Alleged. Allegan News says, remember, everything you're saying will and can be played in court. You are the party to the matter. I mean, I'm not necessarily yet. I guess it's possible that I could be. Now, in my matter, I'm a party to the matter. I'm not a party to April's matter. So anything I say might be played in court. Might, but it might also be hearsay. Now, there's a whole lot of ways in which that can get really fucking muddy. But for now, let's just go with, I know I'm not really that concerned with what I'm saying today. Yeah, actually, if they would like to play the part where I point out where the government lies, like if they would like to play that part of the video, that'll be okay. I'll allow it. I'll even not copyright claim the court. Okay, so here we go, guys. Let's watch this. This is Judge Fisher. Never mind.
487 State versus April Imholte. Note the appearance of Thomas.
Why did homeboy breathe like that? What was going on there? He went, it's like, is he okay?
Gallagher, attorney with and on behalf of the defendant, April Imholte. Kristen Pierce, assistant county attorney, appears on behalf of the state. This is
that's an allegation.
Ms.
You can't
Imholte,
prove that's my studio.
One count of possession of controlled substance, a felony violation of Minnesota statute section 152.025, subdivision 2, paragraph 1, and subdivision 4, paragraph B. Maximum penalty 5 years imprisonment, a $10,000 fine, or both. Ms. Imholte, you have the right to remain silent and not submit to police interrogation. Anything you say may be used against you in this or
It's kind of funny that she would Mirandize April during this hearing and say she has the right to remain silent. Because like the officers did that and then they just ignored it. So that was cool. Good job. Good job on that one. All right, back to this.
Any subsequent proceeding. You have the right to counsel in all proceedings, including police lineups and interrogations. You have the right to be represented by an attorney of your own choosing.
April is very blurry in this. She looks like that Scanner Darkly movie with, I think it was with Keanu Reeves. They had that weird animation style.
You're on expense.
Oh, the guy in the bottom left is a guy named Win by 2. I don't know.
Indigence, then attorney will be appointed at public expense. You have the right to communicate with defense counsel, and a continuance will be granted if necessary to permit this. You have the right to a trial before the court or a jury. Mr. Gallagher has submitted a certificate of representation. Mr. Gallagher, you've also submitted a motion to dismiss, and it's your motion.
It's my
Your Honor,
motion.
When I looked at the complaint, I'm asking the court to dismiss the complaint today based on Rule 17.06 subdivision 2.
Okay, so I'm kind of ignoring this first part, like I'm playing it for posterity, but we just went through his motion. So we know what he's doing. What I'm interested in talking with you guys about is what Kristen Pierce, county attorney, has to say in response to him. And also, one of my just general complaints for the court where prosecutors get to do lawyering on easy mode and they have no fucking rules or standards that they have to follow. It's pretty amazing.
Paren 2, Paren D, and subdivision 3. And as outlined in that rule and in the comment to that rule, if the facts alleged in the complaint do not constitute an offense, then the complaint should be dismissed. And that can be raised at any point in the proceedings, including today. The complaint, the probable cause section, I believe, is about 2.5 pages long. It mentions the defendant's name. There, I believe I put it in my motion, but in writing, but it's 5 times her name is mentioned. The first time it says she was located in the home. The second time it says she was located in the master bedroom. Third time it says 2 credit cards listed to the defendant were found. And then it says the fourth time it mentions her name. It says her purse was located in a hallway between the master bedroom leading to the attached bathroom, and that a co-defendant indicated her
background does not look familiar, you liars. What are you talking about? I'm just kidding. Obviously, she was sitting right here.
Homeowner indicated that the defendant was at the home visiting at the time of the search warrant execution. Mere presence is not enough to support a possession charge. There's no allegation that she possessed any drugs. And so we're asking that the court dismiss the charge.
Ms. Pierce.
Your Honor, Ms. Imholte was found in the room where the drugs were found. She's only being charged with the drugs that were found immediately on top of her credit cards, which were active and not expired. One was a bank card, and
okay, so here's where we get into the meat of this, and this is where it starts to like matter what's being said a little bit more. I mean, the other stuff mattered, but we went through it in the paper motion, so we didn't really need to hear Mr. Gallagher's words, as eloquent and wonderful as they were. We've just now gotten that she's only being charged with the amount that was, quote, directly on top of the cards. And this fact becomes pretty interesting in just a second, because you're about to hear a lie from Miss Pierce.
And her purse was found in the master bedroom suite.
Okay, so real quick, sorry, I just have to do this again. If you're next to drugs, but they're not your drugs, and you don't know that they're there, you don't own drugs. Okay, so this is a kind of a, like, possession is not just you're around something. So if you take the allegations of the search warrant execution, the complaint is true, and you say that there's this controlled substance, and April's in this room, then they go, well, you still have to prove that there's possession. So you can't just like be like, well, they're there. And that's what the complaint was. The complaint was, this was there, April was here, therefore, but except they left out the therefore. So we're now finally getting it. But they're saying that this vial that tested positive for cocaine was sitting on top of a couple credit cards, on top of a nightstand, and therefore April is in possession of that. That's their claim. Now, this gets legally wonky in a bit.
Which between the master bedroom and the bathroom. And she was in the room when law enforcement executed the search warrant, and the drugs were out in the open on top of her immediate possessions with the rest of the
That is not accurate to the police report. And that's an interesting thing there. That is the first time and only time that I'm aware that the state has claimed that the drugs were out in the open. Miss Pierce has misrepresented a material fact right to the court. At least if we're to believe the complaint. Because the complaint, let me just go back to what it says. the complaint says following items were located in the master bedroom near the nightstand: black vial with white substance inside that field tested positive for cocaine and weighed 2.2 grams. That's not out in the open. And the reason that matters is because there's an actual statute in Minnesota that says if drugs are out in the open, then anyone in the room is presumptively in possession of them. It avoids this problem that you can kind of imagine in a hypothetical scenario where there's like a mountain of meth, right, on a table, and there's like 10 people all standing around, and they all go, it's that one's, like, it's that someone else's meth, right? Like everybody's pointing at everybody else's meth. They do the Spider-Man thing. His meth, his meth, his. Minnesota created a law that says if drugs are out in the open, then everyone who's in the presence of them is presumptively in possession of it at the time for the purposes of the statute. And so this is interesting because without that fact, it's possible this complaint is deficient on its face, and it's possible that this complaint is deficient as it still stands, because they're not out in the open. So there's nothing here then establishing possession. They could maybe try, again, maybe they have different facts, I don't know, but from what they've put in the complaint, there's nothing. First of all, they don't even allege the possession, but there's nothing actually establishing the possession by April. The only thing that would be establishing it would be this out in the open sort of comment, puts it presumptively under the possession because of that special statute. And this is one of those things where this is a lie. Like this is an officer of the court. This is the prosecutor in this case, and she's representing to the court that this was different than what is in the actual complaint. You know, that's fine though, right? Like, it's just a felony charge. It's just the government telling people that you did something illegal. What's it matter if they just have the facts incorrect, right? Like, what's that matter? But they do it, and it's not really a. There's not really a polite or useful way to bring this up. That's what makes it difficult as well. I mean, I guess Mr. Gallagher could have objected here. Does he win much from the objection? I'm not quite sure. But what he does now have, in my opinion, is actually this nice piece of ammunition. Because I don't think an objection here actually wins him the case all around. But having the prosecutor now misrepresented the facts on the record, that's a fucking arrow in the quiver.
Contents of her purse also in that room. While mere presence is not enough, that does show.
And actually, there was a subsequent one. If you go through that complaint again, that statement of probable cause, the contents of the purse are not in that room. The contents of the purse are in the purse. Which is kind of a weird sort of misrepresentation that is done by the government actor here. And I'm just not quite sure why they would go ahead and do that. But hey, you know.
That she was in the room and creates a joint possession that she was using, or at least with one of the homeowners in that bedroom where the drugs were out in the open, on top of literally on top of her property, of her bank cards.
There's that in the open thing, not in the criminal complaint at all. Huh? Why is he confused?
For today's purposes, I'm denying the motion without prejudice.
Denied!
I think the motion is not as simple as the defense filing would make it seem, considering Ms. Pierce's take on the evidence, and that the motion to dismiss would be more appropriate for a Rule 11 motion where the parties could dive in a little deeper to present the court with the full flavor of the evidence. And so for today's purposes, it's denied. And Mr. Gallagher, would you like to combine Rule 5 and Rule 8 today?
So there you go. Read out the criminal complaint. Like I did.
Yes.
I did just a
All
second
right.
ago.
Are you
weirdo.
waiving reading of the complaint, deferring entry of a plea, and demanding an omnibus hearing?
Lock her up.
Yes.
And are you wanting the contested omnibus hearing right away? Or do you want to be on the uncontested block first?
I think we'd
Another win for the
rather be on the uncontested block because every now and then discovery issues pop up.
Yep. And that's fine. The purpose in our county for the uncontested omnibus is for the defendant to either demand or waive the contested omnibus. So it does buy you a little time, and then the case is not assigned. We'll assign it once you demand or waive omnibus.
I can't get over she's in Nick's studio. Oh, poor Abe. She's gonna cry.
But yeah, here we'll see what. There's not much left. They're going to go through the release conditions.
September 17th at 2:30.
That's out of 14 days.
Oh, sorry.
Would be the 11th at 2:45.
We would waive any
11th.
time
Oh,
2
limits,
weeks.
by the way.
gosh, I'm thinking, I'm totally sorry. My fault.
Yeah, you're being
Okay,
watched.
time is waived. So
Judge.
the 17th, a lot of our prosecutors are gone.
Okay, I'm not going to sit here and do this actually because it's getting annoying. Look, long story short, they schedule it out and then it goes into the rest of it's uninteresting to me. I'll just summarize. They go into the terms of release. Obviously, this was by Zoom, and clearly, April was attending from the Candy Ojai County Jail, as you can tell by the blurred background. But because of that, the release conditions were set by the judge as a $20,000 unconditional release bail, or release conditions, which would be released on your own recognizance, stay in contact with your attorney, no leaving the state without permission, remain law abiding, and then importantly, a no ownership or use of mood altering substances, including alcohol, which is a standard. If you have a case involving any substance from DUI to possession to sales, they will have a restriction on use of any controlled substances or use of any mood altering substances. And it basically always includes alcohol. Personally, I think that's a little bit, I think that's a really shitty thing that they do, because if someone's charged with, use of, fentanyl or whatever, their use of alcohol isn't related to the fentanyl use. So I don't see any nexus to do that, but they just blanket restrict everything. So that would be the conditions. So the way that bail works in Minnesota is you can either post the cash amount of $20,000, or you can get a bond. The bond would cost $2,000, and then a bonding agent would put up the bail money. If you post the full cash value upon your completion of your case, as long as you make it to all your hearings, you actually get that money back in full. If you post a bond, you're out the money that you spent on the bond. It's a trade-off for having to pay 10% less. But what I want you guys to do, just as an exercise, is go to your kitchen and get the sugar out, right? And get a teaspoon like that you would eat cereal with, and put about fill up a quarter to a half of that with sugar. And then say that amount of a substance amounts to $20,000 of bail. Remember that we haven't, people made fun of me for this because I just asserted, knowing that it wasn't going to change, but asserted that bail in my case, I believe, is excessive. $50,000 bail seems excessive for a first-time possession charge. But hey, that's my opinion, man, or whatever. April's is a 5th-degree possession charge, and I think a $20,000 bail is a little bit much for me. It's kind of wild to think that they're well, that seems reasonable. Like if you don't want to live under the government's restrictions of your liberty, you just pay $20,000. We'll give it back. If you're found guilty and you have a fine or any restitution, we'll take it out of that $20,000. And they know they're going to get it. So it's kind of like they might find a way to spend it or award it, that might happen. But it's, to me, I just have a problem with the way we do bail on this stuff. Certain crimes, right, you have someone who's like beating people or rapists, murderers, etc. Maybe you want some good bail on there, dangerous to society. But other bail, like it's like the numbers are insane, especially when you think of generally who's being charged with possession crimes. Typically, you're dealing with low income people. $20,000 is an insurmountable number for most families out there to just have to come up with. So it's kind of wild to think that's how we do it. And of course, it's only the 2,000 if you do a bond or whatever. In our case, it's only the 5,000 to do a bond. But it's like, I don't know a lot of people with that kind of money lying around. And plus you're paying lawyers and, you have other issues going on that you have to deal with. And it's, it piles up like crazy. And I really do wonder, like the 8th Amendment, it says no unreasonable bail shall be set. And it's like, well, what actually is reasonable bail? We accept bail, but what is, like, conceptually, where is it? But kind of fun. Allegan News says you could save April and wife and admit all of it was yours. You could save all of us and admit all of it was yours. What do you, damn, why don't you try that one? I wanted to talk about the hearing and give that the little nuggets on those lines. I didn't watch other people's coverage. I don't know if they covered it at all, but those lines from the state, that shit matters. And when you're trying to fight it, there's not easy avenues to fight this stuff. People are like, oh, just present your whatever. It's like, it's not like you just walk up with a packet and be like, here. Like, you have to bring it by motion. Then the government tries to like tell you how they did lie, but it didn't matter. Anything else, like it's a fight, and it all costs money and time and time and time and time and time. And people think that like you could just, you just apologize or you just go tell them why they're wrong. It's like, it's not how it works. But in the meanwhile, they create they can trample your rights. They can create these narratives about you and let them run. It's not their fault. Like, what do they know? Everybody else's coverage, again, it's hard for me to watch because I know the story. And so I see them like fumbling around the facts. Not their fault. I'm for once not being an asshole about it. I'm just saying, like, they weren't there for all of these alleged events. Whereas I was, present for it. And so I see it in the very specific way. I obviously have my own biases, right? But I'm not talking about that. I'm talking about literally living in the factual scenario that these other guys don't have any insight into. So I can't really watch their coverage. But I figured no one was going to pick up on the two misrepresentations by Miss Pierce that happened right there in the courtroom. I don't know if anybody else picked up on them. The judge didn't seem to say anything about it. Not that she would. Mr. Gallagher, if he did pick up on them, didn't say anything, which there's not necessarily a reason he should. That's a strategy question. I'm not him, so I have no idea what his mind is on that stuff. It doesn't really matter. But I wanted to point that out because I thought it was a neat little way to show this insular telephone, how fucking damaging it could be. Because I tell you, my life has been severely impacted by the insular telephone game in so many ways. It's great.